the third event in Human Rights in Africa Week, which is sponsored by the International Human Rights Law Society. Today we have with us Mohamad Fofanah from Sierra Leone. And Mr. Fofanah is a human rights advocate, and particularly a children's rights advocate in Sierra Leone. And in 1997, as a young law student in Sierra Leone, he returned to his home in the eastern provinces to wait for the results of his bar exam, a very familiar sounding scenario. Because of intense rebel fighting that had started in Sierra Leone at that time, he had to wait for over a year for those results. So we shouldn't complain anymore about waiting for 6 weeks. During that time, he saw children in villages forced to become soldiers and commit horrendous crimes against their neighbors. One of his university colleagues also was abducted by rebels, tortured, and beaten to death during the civil war there. And many times, Mr. Fofanah and his family had to flee to the mountains to escape danger. But throughout this disturbing time, he immersed himself in the study of children's rights, and today he is one of Sierra Leone's leading advocates for children's rights and a relentless promoter of judicial and legal reform in a country that has been ravaged by rebellion and atrocities. When he was finally admitted to the bar in 1998, Mr. Fofanah helped set up the Sierra Leone Office of the Defense for Children International and provided free legal counsel for both juvenile offenders and victims of abuse. In addition to directly representing clients, Mr. Fofanah has been instrumental in instigating a number of reforms to ensure children's rights in the country. To further strengthen his fight for the protection and welfare of children, Mr. Fofanah and 3 other lawyers founded in 2001 the Lawyer Center for Legal Assistance. And this organization is the first and only organization in Sierra Leone to offer free legal services to indigent and vulnerable victims of human rights abuses in the country. And then in 2003 and 2004, Mr. Fofanah was at Harvard Law School getting his LLM degree, and he's actually the first Sierra Leonean to graduate from Harvard Law School as well. Today, Mr. Fofanah continues working for the Lawyer Center for Legal Assistance. He also does work with Defense for Children International. In addition to that, he is on the defense team for the Special Court for Sierra Leone, which many of us are familiar with, and also helps out with a just mining campaign for the redistribution of wealth gained from mining diamonds in Sierra Leone. So as you can tell, he's a very busy man. But he has taken the time to come here to Duke today, and I would like you to help me welcome him.
Yeah, let me stand a bit, man. Let me start by thanking you for accommodating me and for sparing the moment to listen to my story. I also want to thank the International Law Society for Human Rights for the program, as well as the Sierra Leone Enrichment Program, Educational Enrichment Program, SLEEP for short, for facilitating my presence here. As you may have heard, I'm involved in a number of things back home, paramount amongst which involves the advocacy for child rights in my country, and as well as working with the Special Court for Sierra Leone. I also do a lot of things relating to just mining campaign in my country. For the purposes of this discussion, therefore, I intend to open up to any field of inquiry that anybody might want to engage us in. At the same time, focus on issues of transitional justice and accountability in Sierra Leone. Having worked with the Special Court for Sierra Leone for in the minimum of 5 years, because I joined them in 2004 after completing my master's degree, I have quite some insight into the operations of the court. I mean, although I was doing that side by side with other things, child rights advocacy, just mining campaign and the like. One of the strongest points that as defense attorneys we've had against the court has to do with the indictment. As you may be aware, the court has indicted and convicted 8 accused persons, 2 of whom belong to the Civil Defense Force, 3 to the Armed Forces Revolutionary Council, AFRC for short, and another 3 to the Revolutionary United Front, RUF. All of them were convicted for participating in events during the period 1996 to sometime in 2000 when peacekeepers of the United Nations were allegedly abducted by rebels of the RUF. Now, our problem with the indictment, like I said, has to do with the fact that it is grossly defective in many ways. And although convictions have already been made about against the accused persons that I stood for in most of the trials, we still, as academics and as researchers in the field of law, will continue to challenge the manner in which the process went about. The statute of the special court particularly requires that accused persons be convicted under two main modes of conviction. Under Article 6.1, there is a provision that you can be convicted on direct modes of participation. That is either if you participated in planning, ordering, committing, or aiding and abetting the preparation or execution of a crime outlawed by the statute. And don't forget that these crimes are very serious crimes, crimes against humanity and war crimes, which the court was set up to try. And under Article 6.3 mode, they say you will be convicted if it is found that by your behavior you operated as a superior over subordinates, and that if your subordinates were involved in the perpetration of crime and you fail to take positive steps to either stop or punish the crime, you can also be convicted as a superior. Under Article 6.1, again, apart from the direct modes of conviction, the prosecution introduced a very strange creature called joint criminal enterprise. By that, they said that the Revolutionary United Front and the Armed Forces Revolutionary Council, by some design, came together and planned to perpetrate crimes in Sierra Leone by taking over the government of Sierra Leone and controlling the people of Sierra Leone within a time frame through criminal means. The difficulty with that particular mode of conviction is that with joint criminal enterprise, it has three modes or forms of liability. One, they say if you share the same intent with the perpetrators, what is called basic intent, then you can be convicted if the relevant evidence can support that conviction. Alternatively, if by the fact that you belong to an institution or organization and that institution happens to condone certain crimes, or the crime is said to be systemic to that institution, then you can also be convicted. Similarly, too, you can be convicted under what is called the foreseeability test. In other words, they're saying that if you have joined together with other people, there has to be a plurality of people, and then you design the commission of a crime, and then it happens that that crime is, as a matter of fact, committed, even if it is committed by a stranger, as long as you use that stranger to achieve your objective, even if you are absent, then by some legal device, that crime can be attributed to your conduct as a member of the joint criminal enterprise. So that is the way it was presented by the prosecution, and that is the way the court tried to argue it. Now, the problems we had with especially the joint criminal mode of conviction, and upon which almost all the accused persons were 80% tried and convicted, is that it is not only fluid, but also a very dangerous mode of convicting for international crimes. Don't forget that these are crimes for which the sentence is often, in our case, the minimum sentence we've had is 15 years and the maximum 52 years. So if somebody is to serve that length of time in a prison, then you must be convinced that the person actually participated in the crime, and not just by some fiction of the law through a fluid process called joint criminal enterprise. So one of the main problems we had with that mode of conviction is that the prosecution failed to adequately notify the accused persons and their defense attorneys about the nature of the mode of responsibility. If you look at the indictment, it simply says that the RUF and the AFRC, jointly planned and designed to take over power and to seize control of power in Sierra Leone, and by that means subjected the people of Sierra Leone to various criminal conduct. They did not, for example, categorize what form of joint criminal enterprise, as I've outlined, they were using. They did not adequately notify the accused persons about what they should expect under each count of the indictment. I mean, if they were using joint criminal enterprise, for example, whether they were relying on the basic intent, the foreseeability test, or the systemic, form of liability. There was no such notification. And then even the nature of pleading the allegation that the AFRC and the RUF commune together to gain power, not just to control, but to gain power, is flawed. Because, there is ample evidence, and the court indeed pointed that out in almost all of their trial judgments, that the RUF was never involved in gaining power, that it was only the AFRC, the military guys, who overthrew the government and then eventually called upon the RUF to come and join in controlling the reins of power. So if to that extent there is such an admission, then one begins to wonder as to whether if you are not involved at the initial stage of gaining power, whether by your contribution in helping to control, you can qualify for that mode of liability. But these are all issues that we are looking at on appeal. Although in one of the appeals, at the AFRC appeal judgment, the appeals chamber had said in some form that the basic intent and the foreseeability test pleaded by the prosecution were well pleaded. But of course, that is open to further debate because it was not exhaustively analyzed by the appeals chamber. Another issue we had problems with regarding the indictment had to do with the concept of greatest responsibility, because they kind of said that the threshold for indicting those who stand before the court has to be the greatest responsibility threshold. But then if you take one of the convicts, a guy named Mohamad Fofanah, who happened to have fought with the CDF. And interestingly, the CDF, we are called upon by the president to join him fight against the rebels. So they were in fact pro-democracy. They were fighting to restore, the legitimate government. But then by their conduct, they were also indicted. But this guy, his liability was, as established by the court, was extensively for aiding and abetting. They said he aided and abetted the commission of crimes. And aiding and abetting, as we all know, is, a rather indirect mode of conviction and even of a lesser weight compared to other direct modes. So if a man like that, who was not only stark illiterate at the time, he was indicted, but even at the time the alleged offenses occurred, and the court again acknowledged that he's been convicted because he was present and did not do anything, even though he had a superior called Mr. Norman. If a man like that, just for aiding and abetting, can be categorized as bearing greatest responsibility, it leaves a lot to be desired, especially by the people of Sierra Leone who think that they were fighting a just cause. Of course, there are several other things that we have, with the indictment and the mode of trial. The question of notice. If you are to bring accused persons for very serious crimes and crimes that have the mens rea for which require specific intent, you must notify the accused in detail about what he's supposed to meet in order to respond to such crime by way of defense. But then what they did, they brought broad explanations that the FRC RUF killed XYZ number of people in XYZ district, not just a location. They did not condescend to particulars. A number of other things, like I said, the definition of pillage again. They defined pillage as destruction of property by burning. They said no, taking appropriation of property by burning, that you looted and burnt. Of course, the appeals chamber in one of its decisions has clearly stated that pillage in international law does not include destruction. It is only the element of appropriation. But then how do you amend the indictment at the appeal stage when the accused persons no longer has the opportunity of responding to it? So they had to technically amend the indictment, and then said that, where the evidence says that they appropriated, then they will accept the judgment on that. Where the evidence shows that they destroyed, they will drop. So these are all issues that probably even after the court will look at academically to ascertain the extent to which they went in conducting the entire business of convicting people. But that said, the special court is still, a very useful legacy for Sierra Leone, because in the midst of chaos and confusion, the rule of law was reintroduced by the special court, and they have very useful modes of trial, which is now helping. They have this discovery system, that is that you don't try accused persons by ambush. You must disclose everything to the defense so that they can amply respond. The manner in which they treat accused persons is also in tune with international standards. The way in which the trial is conducted, it is open, free, and fair. It's just that when the judges prepare a judgment, for example, in the RAF trial, it is an 800-page judgment. They only read out the summary. So it is only when you go to the judgment that you begin to see some of these flaws that we have identified as defense attorneys. Now, on accountability issues, again, you have the Truth and Reconciliation Commission for Sierra Leone, because we took a dual-track approach. That is, don't forget that our war spanned for 11 years. And those who actually bore greatest responsibility were not only many, but that they were not even confined to the guys who are now before the court. The main players have either died or have disappeared. You have men like Fode Sanko, Sam Bokari, Johnny Paul Koroma, and then, of course, it was only recently that ex-President Charles Taylor was added to the list. But his trial is going on in The Hague. So I'm basically saying that we needed to have a dual-track approach to capture the accountability aspect for those who are not appearing before the court. So that is why the Truth and Reconciliation Commission was set up. And indeed, they did a perfect job. They encouraged the participation of children. Children were very much involved in the work of the Truth and Reconciliation Commission. And they even had child-focused, groups that presented their own reports about what they wanted done about the participation of children in future conflicts, if any. So it was a very interesting thing. But the biggest problem, the thorny issue which the Commission took up with the Special Court and with the government and the United Nations, was with the amnesty provisions of the Lome Peace Agreement. Sierra Leone had two significant agreements during its wars. The first one was the Abidjan Peace Accord, which was signed in 1996 but failed, and then subsequently the Lome Peace Agreement, which was signed in 1999 but succeeded. Now, in 1999, Issa Cisse, who was indicted and convicted under the RAF and was sentenced to 52 years, actually collaborated with the international community and the government of Sierra Leone to bring peace. And ultimately, when that was done, again at that time, Fode Sanko was around, they decided to give blanket amnesty and reprieve to all combatants and collaborators under Article 9 of the Lome Peace Agreement. And that still stands because it was enacted into law by the Parliament of Sierra Leone, the legislative organ. So when the government of Sierra Leone was about to enter into a treaty with the United Nations to set up the Special Court for Sierra Leone, they never repealed nor did they amend that provision in our law that provided for amnesty. It was still there. But then what the United Nations did was to make a disclaimer that clause, the amnesty clause, did not apply to international crimes and therefore they were not bound by it. So that is what they used to set up the court. But then when the Truth and Reconciliation Commission was bringing out its report, it was very clear, it did not mince its words in attacking the United Nations, the Special Court, and the government of Sierra Leone in their utter disregard of the Article 9 provisions of the amnesty the Lome Peace Agreement. What the Truth Commission said was that, firstly, by virtue of the fact that that was still part of our laws and that the main players in the war were either still at large or some of them were even walking the streets of Freetown, it was in view of the fact that people had gone over much of what had happened, it was in the best interest of the country to bring them together, reconcile them, and then possibly look at other means of accountability. And over and above that, the fact that in 1996, when the United Nations served as moral guarantor to the Abidjan Peace Accord, they never made any disclaimer because the Abidjan Peace Accord too had an amnesty clause. There was no disclaimer. The only problem was that that accord did not succeed. So the accord which did not succeed, was okay, but the one which finally succeeded was not okay with the disclaimer issue. So the Truth Commission also had problems with that. Then ultimately they had problems with the fact that the amnesty provisions was more in tune with the aspirations of the people at that time, because the qualification of those who bore greatest responsibility was pretty fluid. There were so many collaborators in the war on all sides of the factions. And then they also took note of the fact that the civil defense forces especially were fighting a pro-democracy war and that they ought not to have been even engaged in the first place by the special court. So all of that culminated in their attack on against the dismissal of the amnesty provisions in the Lome Accord. So with accountability and transitional justice issues, that is thus far I can go. But then I will now relate it to present trends in Sierra Leone. What have we learned from those issues? The operations of the special court did not take away the legitimate arm of government's intervention in justice issues. By that I mean the operation of the judiciary of Sierra Leone. In fact, the very first thing they did was to bring a motion when the court was about to set up the special court. They brought a motion to the Supreme Court of Sierra Leone to say that that court was illegitimate because the highest court in Sierra Leone ought to be the Supreme Court and not the special court. But then the Supreme Court ruled that that was a hybrid court, a treaty-based court, and therefore was not subject to the special court, the Supreme Court of Sierra Leone. But that said, the Supreme Court of Sierra Leone still proceeded to try, combatants for certain other offenses like murder. In fact, one of those who actually, and his name kept coming in all the trials of the special court, a guy named Savage, who inflicted so much harm on the people of Kono. He was involved in mass murders, amputations, and the like. He was actually tried by the High Court of Sierra Leone in its criminal division and sentenced to 70 years, and he's at the maximum prison. So that shows the way in which the Supreme Court was supporting the work of the special court in at least accessing justice. We also have other organs like the Anti-Corruption Commission, which is helping because one of the recommendations of the Truth Commission about the need to prevent a recurrence of the war was that the issue of accountability in the use of public funds must be addressed immediately. Otherwise, we stand the risk of having another war. So we now have an Anti-Corruption Commission that is pretty much, efficient, because what the Sierra Leone Parliament did last year, 2008, was to make sure that the commission was entirely independent of government. Before now, it was the Attorney General that used to prosecute offenses, that bordered on corruption. But now the Anti-Corruption Commission is entirely independent. It has added new offenses to the old ones. For example, you now have what is called acquisition of unexplained wealth, bid rigging, abuse of office, abuse of power, a number of them that, the net is so wide that you can't easily escape them. And another interesting aspect of that commission is that it has also introduced declaration of assets of public servants. And you can see why that is so, because if you, for example, declare your asset today and then you acquire wealth, unexplained wealth tomorrow, then the difference has to be explained. So that is, I mean, the president has already declared his assets, members of cabinet have, and other public servants are in the process. So I think that is one of the most successful post-war mechanism we are using. We also have the Human Rights Commission, which was set up in shortly after 2004. I mean, it is also addressing human rights issues. There is the Child Rights Act, which has also been passed, the 2007 Child Rights Act. It consolidates all the laws relating to children and then provides for very useful tools of addressing child rights. For the very first time in the history of Sierra Leone, you have informal panels that have now been set up that are to be set up by virtue of the Act in every village or ward with the sole aim of protecting the rights and welfare of children. You have child panels, child welfare committees that will sit at an informal level to address issues pertaining to children, be they crimes or be they offenses by them or against them, so that you don't just bring a child who has been accused of committing an offense or against whom an offense has been committed directly to the formal system, the police and so forth, but you have informal means of looking at it and then to prevent the entire concept of criminalizing the child. I mean, so that is what the Child Rights Act provides for. And then it talks about the age of a child. It says a child is someone who is below 18. Then there is a 3 gender bills. There is one of the bills which has now been passed into law is about the registration of customary marriage. Before now, I mean, it was pretty fluid. I mean, people can marry young children. But now it is clear that you can only marry a child, and the definition of a child is someone who is below 18. You can only marry an adult, sorry, you can't marry a child, I mean. So it's pretty clear, and that marriage must be registered, even if it is done customarily. There is also the Domestic Violence Act, which is also good for women. There is the inheritance law, which has also been introduced, because before now women had problems with inheriting property of their deceased husbands, especially under customary law. So that too is kicking off ground. A number of things are actually happening. There's also the Independent Media Commission, because if I can say one of the things that we really enjoy post-war is freedom of expression. I mean, a number of media houses exist, and because of the extent to which they exercise their liberty to express themselves, a number of them have been quite reckless. So yellow journalism is kind of quite prevalent, and in order to avoid that, they set up the Independent Media Commission, not an arm of government, to regulate the conduct of journalists. Although one of the things that we still have as a drawback is the existence of criminal libel laws, and we are fighting that as well to ensure that we have a Freedom of Information Act to take care of that. So the Independent Media Commission operates really to make sure that journalists regulate their behavior and that they are not criminalized for their conduct. I mean, many other things happened really along the lines, but I think in the interest of allowing questions and so that I can respond to them, I will stop thus far. The only thing, be at liberty to ask as many questions as you can. I was also involved in the Just Mining campaign, as I said, so if you want to ask questions about that, you are free to do so on children's rights, on any issue pertaining to Sierra Leone that I can help with. Thank you very much for listening. Yes.
You mentioned a lot of legislation regarding children's rights, regarding domestic violence, regarding anti-corruption, a lot of new pieces of legislation that have occurred. To what degree is there still an enforcement gap between what the laws on the books say and how they're actually enforced? And if there is indeed still a gap, what is being done to close that gap?
Yeah, that's a very interesting question, and that is what we are actually grappling with. But you know, they say the fear of accidents should not stop us from driving. It's always nice to have the laws, and then you look for mechanisms of, pushing the law forward. Because they will say if somebody commits an offense or if somebody does something that is really heinous and miserable, he He will say, after all, there is nothing stopping me from doing it because there is no law. So it's better to have the laws, and then you have ways of addressing them. Like I said, the most successful one really has to do with the Anti-Corruption Commission, because, I mean, they've done almost everything to set it up and to make it independent. And in their case, they just received about £2 million donation from the British. So that is going on well. But with the others, I mean, there is so much to be done, especially with the Child Rights Act. Imagine setting up a child panel and a child welfare committee, each of which will have roughly about 10 members in each village or ward. And we have no less than 150 villages in Sierra Leone. I mean, so that's going to be a lot. And they're saying that social development workers must be involved in each of those panels. So one of the things that we have started looking at is to, first of all, narrow down the things to chiefdoms, because there are staggered modes of addressing the issues according to the Act. You have to have a village welfare committee, a chiefdom welfare committee, a district welfare committee, and then the National Commission for Children, all in that decentralized order. The essence of that is to ensure that if the chiefdom is not satisfied with what the village committee has done, they can step in to redress the issue. And so with the chiefdom, with the district, and then the National Commission. So it is a new instrument. The National Commission is yet to be set up. No, I mean, there were existing child welfare committees in towns, but those are just experiments. They are yet to be done according to the Act. And then over and above that, like I said, before now, there used to be a free definition of a child. I mean, almost every law has had its own definition of a child. The Prevention of Cruelty to Children Act defined a child as someone who was below 16. The Children and Young Persons Act defined a child as someone who was below 14 and a young person between 14 and 17. The Constitution defined the voting age as 18. The Interpretation Act defined an infant as someone below 21. And those, I mean, so there was actually a need to consolidate all of these things. So for the first time now, we have a singular definition of a child as someone below 18. And don't forget, I mean, the best interest of the child in line with the Convention on the Rights of the Child is posited as a fundamental bedrock of that act. That, I mean, in whatever government and individuals do, the child's best interest must be sought. Although the Act also outlines their responsibilities in terms of working hard to achieve things, I mean. And then it also places a lot of onus on parents, the community, and the government to actually provide for the needs of children. Because what we had post-war was to have a number of children on the streets who were unattended, and there are still children on the streets. So the social welfare department is pretty ineffective. But then with the Act and with a vibrant civil society monitors, we can address that as we move on. So it's not easy, but it's better to have those systems. The Independent Media Commission, for example, it functioned in averting something that was going to be a very dangerous occurrence recently. The two main political parties have radio stations, and they trade words at each other. And they started veering towards incitement, like it happened in Rwanda. And that is pretty dangerous. So the commission came in to, first of all, suspend them immediately. And then there was a way of bringing both parties together to address that situation. So these are all checks and balances. The problem really is that, I mean, we need a lot of support, and as well as coordination of civil society, government, and the like to get things done. Primarily, the judiciary in particular ought to act, because when all other organs fail, it is that organ that should succeed. But it is also fraught with a lot of problems. You know, so let me hear from other people and we'll move on. Yes, sir.
There's a lot of debate in the world of trial of international crimes, you know, of course, about the advantages and disadvantages of locating a court in the country in which it has jurisdiction over crimes that it's trying. Can you talk at all, given your experience with the special court, about your experience of what advantages or disadvantages the actual physical location, presence of the court may bring to your work in terms of how it affects society's perception of the court's work and the legal culture as well? Do you see those effects actually taking place in your work?
Well, like you rightly said, I mean, they have both merits and demerits. In the case of the merits, I mean, there were many in the sense that the people themselves were able to access the court and participate in it, and then they watch it unfold. They were going to court every day to see witnesses talk, so they felt like they were part of it. The accused persons too had easy access to their family members. I mean, if they were going to be taken away, and that is the problem they are now facing because the court is saying that they want to relocate them to Rwanda. So there is this huge outcry. I mean, there were also many advantages in having the court in Sierra Leone. Like I said, I mean, we rediscovered the rule of law, especially at the international plane, discoveries and the like. But then also having the court in Sierra Leone was problematic because, I mean, the very standards of fair trial were undermined by the presence of Sierra Leonean judges on some of the panels. I'll give you an example. I mean, in the CDF appeals, there are 2 Sierra Leonean judges sitting on the appeal and 3 non-Sierra Leoneans, 3 international judges, so it's a total of 5. And then the Sierra Leonean judges, I mean, dissented on the issue of adding on the sentences of the CDF because the 2 illiterate guys who were convicted had sentences of 6 and 12 years respectively. And the appeals chamber, having had the appeal, was about to increase their sentences from 6 to 15 and from 12 to 20. So the 2 Sierra Leonean judges dissented and said that these guys even ought to be out. They ought not to be here because they were fighting a pro-democracy cause and the evidence does not support their conviction. Like I said, one of the guys was merely convicted because he was present and did nothing. He was convicted for aiding and abetting. You know, so the 2 Sierra Leonean judges felt very strongly about it, and then they dissented on the issue of sentencing. And the others went and increased. They did not only maintain the sentences, they increased it from 6 to 15 and from 12 to 20. So that in itself was problematic. And then look at what happened recently at the RUF, trial. It will amaze you to learn that irrespective of the number of years that we are given, 2 of the judges dissented on the sentence, and there are only 3. Only 3 judges sit at the trial, but then 2 of them dissented, but yet they sentenced everybody to high levels of maximum imprisonment. Now, this is what they did. One of the judges said, "I'm dissenting because the third accused ought not to have been sentenced to 25 years. He should have been sentenced to 15. And then the other judge said, "I'm dissenting because the first and second accused were unjustly treated in their sentences because the court did not consider the peace, their peace initiatives during the war, that they in fact brought peace to Sierra Leone and that ought to be a mitigating factor, but that the court did not consider it. And that the court did not also consider that the first and second accused were placed under duress by Fode Sanko, who is now dead and could not face trial. So he dissented and the other guy dissented. So there was only one judge, but yet all of them agreed to give them 25, 40, and 52 years respectively. So that is also an issue that will form the subject matter of appeal. So it has its merits and demerits, but again, the court is still the legacy for Sierra Leone, and it is there. Any questions on child rights or just mining?
I was going to ask if you could talk a little bit more about your involvement with the just mining issue. What sort of things are going on?
Yeah, that's pretty interesting. The just mining campaign actually was firstly about addressing this issue of conflict diamonds. You may have heard about that. There are movies on it. It's pretty interesting. they were trying to talk Mende in the movies, I mean, and it was a bit difficult to understand, but that is it, I mean. So, the conflict diamond issue is pretty interesting. And that is what really brought President Taylor and others at the front. I mean, not only were our diamonds illicitly mined, but then there was also no mode of accounting for the proceeds, especially during and also after the war. I mean, our diamonds were going out, and that is our main source of income. So there was need to actually, first of all, rediscover Sierra Leone diamonds and their value. And then the Kimberley process was brought in. The Kimberley process is all about certifying diamonds according to their origins, their roots. So that when you bring a diamond to Antwerp in Belgium, they know the source, and then they can accordingly say this has nothing to do with blood or war, as the case may be. We can allow it in the market. But then apart from that Kimberley process, the local just mining campaign which we started was to ensure that we direct the minds of both Sierra Leoneans and the international community about the fact that the diamonds were not even benefiting the communities. That, I mean, don't forget that in order to mine for diamonds, you have to excavate the subsoil and probably dig down. They were not reclaiming the lands, and a number of things, hazards were occurring. So there was need to actually look at that. So the Just Mining campaign was about making sure that, I mean, mining was done responsibly, and that it also benefited the communities. And we were also propagating the contents of the Environment Protection Act of 2000, which said that in order to mine or in order to be involved in dealing with extractive minerals, you must conduct an environment impact assessment, so that you tell us how you hope to go about it, how you hope to benefit the community, how you hope to reclaim the land. And then, we have a responsible way of approaching it. So that is what we were doing. We were engaging government, because we also realized at some point that the government too was colluding with so-called investors to ignore those problems because they were getting kickbacks. So we had to raise the issues and then talk about it, and people started listening. Now they have new mining policies. I mean, mining contracts are being revisited, because there was also this problem of people just taking certain licenses and then going to do something else. I mean, they could come in for exploration license, for example, just to explore, and then use it to mine, just because they don't want to pay royalties or taxes, as the case may be, and because it is cheaper to have an exploration license than to have a mining license. So we drummed all of these things up, and I mean, things are now happening. The mining contracts are being revisited. There is now a core mineral policy to look at, oversight in the mining of minerals and towards the payment of royalty. And then there is also the investment act. I mean, which talks about encouraging foreign investment. It says that there are no barriers to registering your business, and that there are also no barriers to repatriation of your profits, as long as you meet the taxes that are imposed. And then that if you also want collaterals, I mean, it is open. You need not be a Sierra Leonean per se. So the investment code is also there to open up the country. There are few hiccups with other things like land acquisition, but that also is being reformed. Because especially in the provinces, land is not individually owned. It is owned by the community. I mean, in the person of the paramount chiefs and the like. So government is trying to see how they can loosen that a bit, because what you acquire in the provinces are leaseholds and not freeholds. So, I mean, that also is ongoing. Yes, sir.
Yeah, I have a few questions, but if somebody else has another one, please jump in. In your work on child rights, everywhere where you do work on child rights, I think there's kind of a mentality that needs to be changed socially, as well as a set of legal relationships that need to be changed. I mean, the way, different societies look at children is very, very individuated, but in almost every case, you see that there's certain biases that you have to work against. When you're working in your child rights advocacy, who are your biggest partners in the work you're doing? Are they local? You mentioned chieftains in the regions that are subject to the mining, figures like that. Who are they? Religious figures? Who are the most influential people that you can work with to help reach into the community itself?
Well, yeah, I mean, I think that one is pretty circumstantial. It depends on the case that you are dealing with. For example, if you are talking about children in the mines, you have to work with the community leaders to make sure that they have bylaws that will actually prohibit that, and to make sure that they actually relocate and divert the children into schools. And then if you are talking about juvenile delinquents, for example, you actually possibly need to involve the parents of the affected child, and as well as the Ministry of Social Welfare, to look at diversion issues and not just about criminalizing the child. I mean, of course, you also have the juvenile courts to make sure that the right thing is done, because the court ought to sit as a non-adversarial court. It's about making inquiries into the background of the child and then see what you can do towards diverting or reforming the child. And a number of other issues, because don't forget that we are not only dealing with children in conflict with the law, we also deal with what is called children in contact with the law. I mean, for example, you are said to be in contact by virtue of the fact that you are a victim of sexual abuse or, child labor. Or sometimes you are said to be in contact by not doing anything at all, like status offenses, let's say loitering. And it's pretty common in our situations to actually see the police charge a lot of children to court for loitering. They are just found somewhere, they haven't done anything, but they are found somewhere within a period, and then they say they have committed crimes. And these are children. In fact, under the new laws, they are said to be in need of protection. A child of that nature is said to be in need of protection and not to be criminalized. So in situations like that, you have to see where to balance the scales and see, you emphasize. That is why I'm so happy with the new Child Rights Act. You don't just bring children directly to the formal justice system. You look at the other informal means of, taking care of that child. And it is only when there are very serious offenses involved that the formal justice system comes in. So it's that kind of approach. Yes, sir.
It seems like just mining, children's rights, and the special court, they're all, related in terms of, the roots of the Civil War. Could you talk about the ways in which they're related?
Their relationships?
Yeah. From what I understand, the mining was there was a lot of part of the reason that the Civil War happened was conflicts over the way diamonds were being mined, and a lot of the problems with children's rights was the result of recruitment of child soldiers. So could you just talk about the way all three issues are related?
Yes, well, actually, the problems are still ongoing. Notwithstanding that the war has ended and these transitional justice mechanisms are almost about to wrap up. In fact, the Truth Commission has wrapped up completely. It's like they were merely foundations to addressing those problems, because we knew that the problems were going to be with us for some time. So, for example, the mining issues, the Kimberley process was brought in to address only the issue of conflict diamonds, because at a point they were not going to accept diamonds from Sierra Leone because they said, those diamonds were traded in by rebels who were fighting violent wars. So we needed the Kimberley process to, give meaning to the marketing of our diamonds. But then that has nothing to do now with, the mining of minerals by children, for example. You see, because I mean, the background of poverty kind of most times encourages children to move in the direction of fending for themselves and their parents, because a lot of times the parents cannot provide for them, especially if they live in the mines, the mining areas. So there is a temptation to have children actually placed in mines to mine, and then whatever proceeds they get, they probably help to feed their families. So that in itself, I mean, is against the act, and it's a form of child labor, whatever way you look at it. So we now have processes whereby bylaws are passed in especially mining communities that children ought not to be, I mean, anywhere around the mining sites or anywhere around labor issues between certain periods. And even if, I mean, it is outside of those periods, they ought not to be in certain places. So that is one way of encouraging children to be in schools. For example, if the bylaw says between the periods of 7 a.m. and 5 p.m. the child ought to be in school, then that is one way we can address that issue. But then, I mean, don't also forget that mining issues are ongoing issues. I mean, we do not only have diamonds, we have rutile from which you can get titanium. So, I mean, the deposit of that is pretty large, and there was this Sierra Rutile mining company that was involved in it, but then it had to halt its operations because of the war. So they went back in, and we were trying to look at how beneficial their operations were going to be to Sierra Leone, because it also involved, in fact, in the case of rutile, I mean, it's massive excavation of the land, and then destruction of the flora. So, I mean, how was Sierra Rutile, for example, going to take care of the ponds that it was creating in large sizes? I mean, you know, so reclaiming the land, aqua fishing, these are all issues that, I mean, bordered on just mining. And then also providing for the communities, because some of these communities are pretty backward, notwithstanding that so much is being exploited from their soils. I mean, so it's an ongoing issue, really. It's an ongoing issue. Mining issues are ongoing issues, especially for the youth, because those who actually give the what is it called? The energy, those who provide the energy, the physical support, are often young people. They are busy sometimes, they really do it for pittances, and that's also not good for their welfare. So there has to be ways of redirecting them. Yeah. Before you do, can I just ask you a favor? Because SLEEP, that is the Sierra Leone Enrichment Program, wanted a picture for their records. Can you kindly help?
Yeah,
the car. Oh, she's done so?
Yeah, she did.
Oh, okay, no problem. Okay, thank you. Yeah.
You've been talking a lot about criminal liability. Is there any effort to create like a victims compensation fund or something along those lines in Sierra Leone to compensate victims of crimes against children, or even the communities that have been affected by the mining?
Well, that is one of the biggest drawbacks of this entire accountability and transitional justice issue, because that was part of the Lomé peace agreement. There must be a war victims fund to take care of the victims who suffered, especially amputees and women and children. But unfortunately, while so much money was spent trying just about 8 or 9 people, I mean, no war victims fund was set up. And that has been one of the biggest criticisms of the entire process. So what people are looking at, really, various NGOs and the like, is ways of engaging people in vocations. I mean, in the case of children, don't forget that those who were actually disarmed and demobilized were reintegrated into society. They were placed in schools. They were given packages and the like. but then they still have to continue after outgrowing their childhood. So one of the ways of addressing that is to provide for their vocation. You know.
So I think our time is up at 1:15. So thank you so much.
Thank you.